Good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Wednesday, February 20th, 2019. The time is just after 9:00 a.m., and we are meeting in the Hearing Board room in Diamond Bar. This morning we have two matters on calendar. The first being SCAQMD versus Mission Foods, case number 5400-4, for an order for abatement as stipulated. And then we have SCAQMD versus the City of Westminster Fleet Department, case number 5647-2, also for an order for abatement that is stipulated. Unless
all parties are here and present.
Okay, so unless there's any objection of the parties, I'm going to take the cases in order of how they appear on the agenda today. And so I'm going to call the first case, which is SCAQMD versus Mission Foods.
Madam Chair?
Yes.
No objection, but I am going to express a preference if this board is amenable to it. The matter with the City of Westminster, I anticipate being a brief matter that this board is familiar with because you heard a similar request on February 5th, and the members here to represent the City of Westminster are here on the taxpayer's dime. So
Okay.
if you consider that as factors, we'd request Westminster to go first, but we defer. All parties are ready to proceed.
Okay, and I'm just going to ask, who is representing Mission Foods today?
I'm an attorney, James Arnold.
And Mr. Arnold, do you have any objection to proceeding as was requested by the district with the City of Westminster first?
No.
Okay.
Save the taxpayers money.
Okay, then we are going to do that for the very good reason that was expressed by Ms. Manwaring. So let's begin instead, and I'd like to take, let's introduce the case and then just take a few minutes for the board to switch the papers that are in front of them.
Madam Chair?
Yes.
Without objection, I'd like to approach Mr. Beach from the City of Westminster just briefly.
Okay. Well, actually, let's just go off for a minute just to switch our papers, and then we'll introduce the case. We're off the record. Okay, we're back on the record. So I am calling, as requested, first case SCAQMD versus City of Westminster Fleet Department, case number 5647-2 for an order for abatement. And who is representing the executive officer today?
Karen Manwaring on behalf of the executive officer.
Thank you, Ms. Manwaring. And who is representing the City of Westminster Fleet Department today?
Kevin Beach, Fleet and Facilities Superintendent for the City of Westminster.
Can you spell your name for the record?
KEVINBEACH.
Thank you very much, Mr. Beach. Okay, I'm going to ask anyone who wishes to testify or may be called to testify today, including anyone from the public who may wish to testify, to please rise at this time to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Okay, thank you. I see we have a much fuller room than normal, so I just want to make a reminder to everyone who is present today to please silence your cell phone at this time. Okay, Ms. Manwaring, would you like to begin with the opening statement?
As a preliminary matter, could we mark some exhibits?
Yes, thank you. Let me do that now. We've received, I understand, 3 exhibits for marking. We have a proposed stipulated findings and decision in this matter, and we'll mark that as exhibit number 1. We also have the declaration of Ms. Kirsten Melville, and we will mark that as exhibit number 2. And we have what looks like a schematic. It is called the Fueling System for Westminster City Maintenance Yard. Is that a district?
City's exhibit, please.
City's exhibit. Okay, so then we will mark that as exhibit A, as in apple. Is there anything else to be marked? Any preliminaries? Okay. Ms. Manwaring, your opening, please.
Thank you, Madam Chair, and good morning, members of the board. The district filed this petition seeking an abatement order stipulated to by the city and directed to the city to allow them time to work with ARB through its application process for a site-specific certification for its vaulted tank at its fueling facility. When ARB was certifying configurations for Phase 1 and Phase 2 vapor recovery, they overlooked vaulted tanks. That certification didn't come into play until September of 2014, and that started a 4-year clock requiring those facilities with vaulted tanks to have their upgrades in place by September of 2018. You'll hear testimony from Mr. Beach about the unique aspects of this site and how it's designed to survive and serve in the event of a natural disaster. But because of its unique design, specifically safety concerns over the spill buckets, the city was not able to employ the configuration certified in September of 2014 by the September 2018 deadline. You'll also hear testimony from Mr. Beach, who has been working for the city at this facility for years, about how we arrived here and what was happening at the facility in terms of construction around 2014 and why compliance wasn't timely achieved. Some of the information that you'll hear today may sound familiar. My colleague, Nick Sanchez, was before you on February 5th on a very similar matter. You'll hear information about site-specific certifications for gasoline dispensing facilities with vaulted tanks, and many of the same facts about ARB's process for site certifications and the district's role, including an advisory in February of 2018 and subsequent enforcement actions, will sound similar. Please note the declaration that's been marked Exhibit 2 by Kirsten Melville, and she's here to my right and will be able to answer any questions you may have. There are some key differences, though, from what you heard earlier in the month and this facility. Mainly, the City of Westminster does not sell gasoline. It fuels its own fleet at the facility. Because it fuels its own fleet, all of which are equipped with ORVR, the city is able to avail itself of an exemption provided for in Rule 461 for the Phase 2 side requirements. So we're only talking about the Phase 1 upgrade, a site certification working with ARB for the Phase 1 upgrades. Also of key import, the city's fuel facility has a backup power supply, and it supports various first responders. The Orange County Fire Authority, West County SWAT Operation, and Water Emergency Response Organization of Orange County are all supported by this facility in the event of an emergency. Red tagging this facility was simply not an option, and we've been working with the city in order to determine a compliance path. We've presented a proposed order that will allow the city to work with ARB while keeping the district informed, and the district asks that you issue the order as requested based on the evidence and testimony you're about to hear.
Thank you very much, Ms. Manwaring. Mr. Beach, if you have an opening statement.
Thank you. Thank you, Board, for the opportunity. And I'd just like to reiterate what Ms. Manwaring stipulated, that this is a unique facility and that it is a vaulted tank, but it is an all-in-one facility. You actually park on top of the tank when you're fueling. So it is not a vault in one position and then fuel pumps in another position. So in order to comply with the spill bucket regulation, we would have to destroy the structural integrity of our vault. And that, being that it is an all-in-one system where fuel and vapor cannot escape and groundwater cannot enter, it is the safest system that could be constructed. And that's why we elected to do it in 1993. It has been in operation without fault for 26 years.
Thank you very much. I should have asked to begin with so that the other matter has some idea of timing. Ms. Manwaring, are you planning just Ms. Melville and only for questions?
I'm going to question Mr. Beach directly in order to elicit some information to inform the board. And then if you have questions about the declaration, I'll defer to the board. So I would anticipate you being in deliberations in less than 40 minutes.
Okay, and I assume, Mr. Beach, do you agree with that?
Yes, I do.
Okay, so just so that the other party understands, and we'll probably take a break before the next, so I would say 10 to 10:15, no sooner than that. So if you'd like to take some time, we won't get to you until then. Okay, so Ms. Manwaring, however you'd like to proceed and whoever you'd like to call first.
With Mr. Beach's permission, I'd like to do some direct questioning.
Sure, please.
I've already heard you state and spell your name for the record, but could you also affirmatively answer, did you take the oath when it was administered?
Yes, I did.
All right. And what is your position with the City of Westminster?
I'm the Fleet and Facilities Superintendent.
And how long have you been the superintendent?
18 years.
And prior to that,
The shop foreman,
also with the City of Westminster?
City of Westminster.
Okay. And you're familiar with the contents of today's petition?
Yes, I am.
And the city stipulated to that petition?
Yes, we did.
And you're familiar with the terms of the proposed order?
Yes, I am.
And the city stipulated to that as well, right?
Yes.
And did you actually watch on YouTube the hearing that was held on February 5th in order to familiarize yourself with this process?
Yes, I did. I watched the proceeding with Jack Oil on that day.
Great. All right. Referring to the referring to the petition that was stipulated to, that petition is signed by a Mr. Eddie Manfro. Mr. Beach, who is Mr. Manfro?
He is the city manager for the City of Westminster.
All right. And as the city manager and the city attorney authorized you to speak on behalf of the city today?
Yes, they have.
And you're authorized to bind the city to the terms of the proposed order?
Yes, I am.
Okay. All right, Mr. Beach, do you recall first meeting me on or about October 31st at ARB's El Monte office?
Yes, I do.
All right, and at that time, you on behalf of the city, me on behalf of the district, and ARB met to discuss ARB's CP 201 application process. Is that correct?
Yes, it is.
All right. And would you agree that you are familiar with the measures necessary in order for ARB to certify your site as configured?
Yes, I am.
All right. District Rule 461C4 provides a compliance alternative where only vehicles that are equipped with ORVR and owned by the operator are fueled is exempt from Phase 2 vapor recovery. Does the city intend to avail itself of that exemption?
Yes, we do.
All right. Are all, with the exception of emergencies, where you would also fuel first responders and emergency responders, do you only fuel vehicles owned or operated by the City of Westminster at this facility?
Yes.
All right. And are all the vehicles equipped with ORVR?
Yes, they are.
All right. On or about January 15th of this year, did you issue a purchase order to Tate Environmental Services of Fountain Valley, California, in order to assist and complete the upgrades?
Yes, I did.
So if I refer to the contractor, we understand that we're referring to Tate Environmental Services?
Be fine.
Okay. Here's a question that this board is really going to want to know because they like having backstops in their orders. If ARB doesn't extend the R&D letter that it issued, or if they otherwise decide not to certify your site, what's your plan B?
Plan B would, I cannot see how it could not pass certification because it's such a simple upgrade. But if there were some reason that compliance couldn't be achieved, we would have to literally destroy the site and rebuild.
And that's because of structural security?
Structural security of the vault. We cannot simply cut a hole in the top of the vault because all those vehicles of all weight classes park on top of that vault when they're fueling. You can't simply cut a hole in it and change the spill bucket. There's no structural integrity left.
And as far as you know and understand, is there any other fueling facility that has a similar design in the district's jurisdiction?
No, as all of our investigations say there's no other fueling station in your jurisdiction that's built like this.
All right. Thank you very much for that information. Now I'm going to ask you another tough question. What happened? Why isn't the city in compliance with ARB's regulations, and how did the city find itself in violation of District Rule 461?
So when the issue was first ordered in 2014, we had just closed the site for reconstruction. The city yard was rebuilt over the course of the next approximately 18 months. We returned to the site and reactivated the fueling station, which was in early 2016. Our primary mission at that time was to get the site back in operation because fueling off-site was costing us at least 35% more than it was to fuel on-site. So those were our missions at the time. As time passed, there were multiple other priorities, and I did not return to it until the reminder letter was issued in February of 2018.
Let me interrupt you briefly. What you're referring to is the compliance advisory issued by the
Compliance
district
advisory.
in February 2018?
Yes.
And that's attached to the petition as an exhibit.
And I should back up just a bit. While we were in construction, I did contact Randy Matsuyama to ask, what does this mean to me with my vaulted tank? And he advised us of the ORVR exemption for Phase 2, and that we would address the other Phase 1 components when we got back to the site. So when we did return to the site and reopen, I contacted our vendor, who has been our maintenance vendor for my entire career, and they said it should be a 2-day operation and it should not be an issue. I said if we need to include 90 days for permit process, the most we should need is 3 months to comply. So when we received the reminder letter in February of 18, I contacted the vendor and said we need to get moving on this and get into compliance. They arrived on our site in approximately June, and the vendor's exact words were, "Oh, that's right, you have this thing, and we can't work on it." I then queried 4 other vendors who all said the same thing: we will not touch it because of the structural integrity challenges. So that's when I called the district and said, I need help because no one will work on this. We cannot change the spill bucket.
Right. And did the district issue a notice of violation on or around September 25th of 2018?
Yes.
As a result of the noncompliance?
Yes.
All right. Other than a district permit, which has already been issued to the city of Westminster, are other permits required in order to complete the upgrades?
So we have a building permit and a fire authority permit, and Orange County Fire Authority is our fire service provider, so all permits will be handled through our building division. I don't expect there to be any delays in that.
All right. And what's the status of the submittals for the other permit applications?
Everything should be into our planning department by the middle of next week.
Okay. And again, the building permit will be issued by the city of Westminster's
Yes.
building department.
Yes.
So it'd be fair to anticipate some priority?
Exactly.
I said priority, not special treatment, just priority. All right. So as you sit here today, do you feel confident that you know what is expected of the city in order to obtain a site-specific certification by ARB for your vaulted tank?
Yes, I do.
All right. I have no further questions for this witness. Oh, actually, excuse me. Let's refer briefly to what's been marked as Exhibit A.
Yes.
For foundation. Is this a schematic that you provided to me in October of last year?
Yes, it is.
All right. Do you want to briefly describe to this board what we're looking at?
Certainly. So what you have here is the side view of our fuel island facility. You have a concrete vault below grade with the 18,000-gallon 2-compartment tank illustrated there. Directly above it, as pictured, is the gas dispenser and the diesel dispenser. There's a hatch on the northern end so we can access it for the daily inspections. It has a canopy above. And if there are any other details or questions you have about it, feel free to ask.
The district has no further questions for this witness.
Thank you. Board members, anyone have any questions? We'll start with Mr. Balagopalan.
Morning, Mr. Beach. Your fleet, how old are your fleet right now, the fleet vehicles? And what, do you phase them out periodically, the fleet?
Yes, we do. So I don't know the oldest vehicle, that would be a diesel, but the oldest gas vehicle is probably 2009.
And they all have ORVR?
Yes, they're all ORVR,
And
yeah.
ORVR is,
All of our gas vehicles are ORVR compliant.
so that's onboard refueling vapor recovery canisters in the cars, in the newer models? Okay. So one of the, except for emergency vehicles, right?
Emergency vehicles are primarily diesels,
The diesels?
and even the battalion chief Suburbans, et cetera, are new enough that they're ORVR compliant.
So who uses the fleet vehicles?
So we have the police department, we have all of administration, we have all of public works. So you have streets, parks, water, fleet, building maintenance, building inspectors, our streets construction inspectors, all city functions use the fleet.
Approximately how many cars would you say? 200.
200.
Now, do they fuel themselves when they come to the station?
Yes, they do.
There's no attendant or anything? So one of the condition of the order, and let me take you to that. I can find that in a second. On condition number 6, it's on page 6.
Let me see if I have it.
I'm going to share my copy with the,
Thank you. Okay, yes.
You see that condition?
Yes, I do.
It says that maintain a list of all vehicles, including make, model, and year to which gasoline is dispensed, and shall make a list. Now, how are you propose to do that? Because if people are coming and going and,
Our fleet is automated fueling. You cannot get fuel without entering what we call a fob. So similar to a door fob, you arrive at the pump, you enter the vehicle's information, swipe the fob in front of the reader, and that's activates the pump and records all the data.
so that's a central place where that information, so you
the
can
fleet-
pull data from there
The fleet
to
maintenance,
provide.
the fleet data, fuel database then downloads to the maintenance database. So all are cross-connected and cross-talking.
And so you can easily provide that to the
Yes,
district?
easily.
Okay. What is the issue with the spill bucket, and how is that going to be resolved with CARB?
The issue with the spill bucket is the regulation calls for a spill bucket that has a 5-gallon capacity, and it also has a drain valve within it that drains into the fill tube that drops into the tank. Because we can't change it, CARB has no concern with us not changing it. We have a separate pump to remove any spilled fuel from the bucket without dropping it back into the tank. So CARB has no concern over us not changing the bucket.
Okay, thank you.
I'm just looking at dates. I think we have an incorrect date. Is that correct? On page 6, paragraph 8, the condition, the end date of jurisdiction is February 20th, 2019. That should be 2020?
please.
Yes. Okay, and then I want to make sure that that is, I want to go through some of the order and make sure that, that it's agreed upon, but do we mean to say whichever is later? So if ARB does certify the Phase 1 configuration before February 20th, 2020, do we wish jurisdiction to continue until February 20th, 2020? Or is that compliance and,
Compliance will be achieved when the certification is issued, so it is not necessary to retain jurisdiction after compliance with the order is achieved.
so perhaps whichever comes first? Does that make more sense?
My concern with that is if it's not in compliance by 2020, the hearing board would lose jurisdiction.
And we don't believe at that time that it should be, it could be extended or should be extended, or do you wish to push the date out further so that we have a definite stoppage date on it, but for sure certification will comfortably fit within that timeframe?
Chairman Prusek, you raise a good point here, and I apologize for not catching it myself. It could be that, or we could add the language that you often see. If the configuration is not certified by that time, this order shall be modified and extended, or something like that.
Okay, we'll work on that. And I assume, Mr. Beach, that you would agree with one or the other? Okay.
Yes.
I'm not sure if I caught this, but the upgrade equipment, it has not yet been installed? It's not yet? Okay, so then you agree with the 14 days. Well, let's just start on page 5. Condition number 1, to commence that installation within 14 days of obtaining all those necessary permits, et cetera.
Yes.
Okay. And the application to ARB, that is in condition 4, you agree to that as well?
Yes.
Okay. I don't think I have any other questions. Anyone else have any questions from Mr. Beach? Ms. Bird?
And just to piggyback on that, and I believe you said your testimony was very fast, by the way. But anyway, I believe you said that there would be, you had estimated 90 days total to complete all the permits. Is that what I heard you say?
No, that was my estimation before the deadline.
Okay.
My vendor said they needed 2 days to complete the upgrade, and if I allowed 90 for permits, then we should need no more than 3 months to complete it prior to the deadline.
Okay. And let's see. And all permit applications will be completed by midweek next week, you said?
They
Is that
should be,
correct?
yes. That's our estimation.
Okay, thank you.
Anyone else have any questions for Mr. Beach? Senator, did you have any questions?
You requested, according to the letter from ARB, research, R&D,
Yes.
for what purpose? I mean, you may have mentioned it already, but I just want you to state why you went to ARB to get an exemption.
It's part of the process to gain abatement.
You think you meet the deadline based on number 7 of the stipulation
Yes,
of June 1st, 2019?
I believe so. I have no reason to believe we will not have it done. That's quite a ways from now, and we're so close to being started, I cannot see why we wouldn't be done on time.
Thank you.
Mr. Balagopalan?
Mr. Beach, I had a follow-up on that fob when they put in. Can you differentiate when they log in which were, I mean, you can tell if they dispense gasoline or diesel.
Yes.
And there's an assumption that all the diesel is only going, because for emergency vehicles or diesel vehicles, is that?
So most of the emergency vehicles that would have, if we had some sort of a mutual aid situation where people came to us for fuel, most of those would be diesels. But we also have our own construction equipment that's diesel operated.
Right. But for gasoline, are they also are there some emergency vehicle that are powered by gasoline?
Yes.
And can you tag, because I think one of the condition on the permit says, it should be only ORVR except for emergency vehicles. So can you, when they fuel that, can you differentiate or in the system that this emergency versus non-emergency vehicle?
For the majority of people who would be able to fuel at our facility during an emergency, they already have the fuel fob from the city, so they would be tracked just like our vehicles. Any other, I would say, larger or outside agency that does not have that fob, we would literally turn the pumps into manual mode and write it down manually. Someone would be at the pump at that point. But that would be some sort of a very large disaster if that happened.
So you can indicate on that list you provide the
Yes, I
inspector
can-
which way emergency, non-emergency.
Exactly.
Thanks.
Okay, any other questions, board members? Seeing none. Ms. Manwaring, at this time, would you like then to introduce Ms. Melville?
Yes, I'm going to introduce the witness and then submit her testimony in the declaration and offer her for questions.
Okay, so let's, first, let's ask Mr. Beach if you have any objection to admitting exhibit, what is it, 2? Ms. Melville's declaration as evidence.
No, I do not.
Okay, then it is in evidence. Ms. Manwaring, you may proceed.
All right. Ms. Melville, could you please state and spell your name for the record?
Kirsten Melville, KIERSTEN MELVILLE.
And did you take the oath when it was administered this morning?
Yes, I did.
What's your position with the district?
Air Quality Analysis and Compliance Supervisor.
Right. Did you prepare the declaration that is here as Exhibit 2?
Yes, I did.
Right. And all the information contained in here is in your personal knowledge?
Yes.
All right. Board members, I defer to your questioning of Ms. Melville if you have any.
I just want to check with Mr. Beach. Do you have any questions for Ms. Melville?
No, I do not.
Okay. Board members, do you have any questions for Ms. Melville? Understanding that we have the declaration and we also received very similar testimony as we were reminded by Ms. Manwaring in similar cases. I see none. Okay, well, thank you for being here, Ms. Melville, and for submitting your declaration. Mr. Beach, do you have any other witnesses you wish to present at this time?
No, I do not.
Okay, so then the parties wish to present nothing further. Okay. Would you like, well, I guess we don't need it. Okay. I'm going to ask then at this time if there's any member of the public who wishes to be heard on this matter. And I see none. Board members, anybody like to begin the discussion on this matter? If not, I can. And I want to refer us to our new handy-dandy quick reference chart. If anyone hasn't noticed, it has been laminated, and so we're in order for abatement stipulated, and which is District Rules 806B, and we do not need to make any particular findings other than good reason and good cause. And I can begin the discussion, and I think I can certainly find good cause to adopt this stipulated order that has been presented in Exhibit 1. As we heard, I don't want to bring in any evidence or discussion from another case, but we are all familiar with the issue of these vaulted tanks being unique. And this particular facility is even more unique in that it does fall within an exemption of the rules because it does not sell any gasoline and instead only refuels those which the city does own. And emergency vehicles, and the vehicles do contain onboard vapor recovery themselves, and so do fit within that exemption. And so the only issue is this Phase 1 issue and the spill buckets, and we understand that in order to comply any other way than the way that is presented in the stipulated order through CARB certification, would be to essentially destroy the facility as it is and rebuild it. And so with that, and given the timeline that is presented and going through ARB, which we did hear from Mr. Beach, I think they do all believe the certification it will be certified, this configuration. And so with all of that, I believe that there's good cause. Of course, these are emergency vehicles. We're talking about the city and other vehicles, but the city of Westminster. And so I think with all of that, there is good cause to issue this stipulated order. Is there any other discussion, Mr. Balagopalan?
No, I agree. I think we can find good cause. And since they're working diligently with the Air Resources Board to get the certification, they should, looks like Mr. Beach indicated, they shouldn't have any problems passing the test and getting the certification from the state. And there's provision in the order, I think if they, I think it's condition number 7 that says that if, let me read that, excuse me. If they, they can request an extension in the event that they need to, and but if it's not extended, then they have to come to the board to modify the order within 14 days. So I think that's addressed in there.
Thank you. Anyone else have any thoughts? I would like to just check with the parties then before I make a motion, and that is with regard to Condition 8 and jurisdiction of this board. And Ms. Manwaring, I don't know if this is what you were thinking, but to leave it as is, that sentence as it reads, and then to add something like if ARB has not certified the city's current Phase 1 configuration, including the spill buckets, by February 1st, or we could do January 15th, 2020. I don't know what makes sense with the 10-day notice requirement. That respondent shall file a petition to modify and extend this order.
The district agrees with that. We picked February 20th because today's the 20th, but I understand the distinction.
Just the date by which they would have to file.
I like a first because it's a nice round number and it's
Okay.
easier to remember.
Let's do that then. And Mr. Beach, do you agree with that?
Yes, I do.
Okay, then I'm going to add that and when I make the motion. Okay, then I will make a motion in the matter of South Coast Air Quality Management District versus the City of Westminster Fleet Department, case number 5647-2. I move that we grant the proposed stipulated findings, decision, and order for a stipulated order for abatement in this matter that is contained in Exhibit Number 1, making the changes to delete the word proposed, both in the footer and the caption. And I believe the only other change that I would propose, as I was just checking with the parties, is on the final page, which is, I wrote over the page number 6, condition number 8 of the order. We will leave the first sentence as it is. Do we say, I think, though, we would have to change whichever occurs first. Does that make sense? Okay, yes. Okay, so that first sentence will now read, first of all, we'll change the date from 2019 to 2020 and the word later to first. So it will read, the hearing board shall retain jurisdiction over this matter until CARB certifies the city's current Phase 1 configuration, including the spill buckets, or until February 20th, 2020, whichever comes first. And then add a sentence, if CARB has not certified the city's current Phase 1 configuration, including the spill buckets, by February 1st, 2020, comma, the respondent shall file a petition to modify and extend this order. Is that what- Just want to make sure, what are they referred to as? Respondent or a facility? Facility, right? Respondent, okay, we'll leave it as respondent. And that completes my motion. Is there a second? Ms. Byrd?
I'll second it.
Okay, any discussion on the motion?
Yes, how do they comply with
Do you want to speak into the microphone?
the last sentence that you added? How do they compete with item number 4 of the order? I mean number 9,
8.
where it says the hearing board may modify the stipulated order. That's what you're speaking to, and adding that sentence, aren't you?
No, it's number 8, our jurisdiction. That number 9 will remain as is, which just simply allows for any modification upon, without stipulation of the party. That particular paragraph is always in stipulated orders. What I was referring to was condition number 8, which sets forth the length of jurisdiction over what this, the length of time over which this hearing board shall have jurisdiction in this matter. And we wanted to make sure that if certification doesn't occur by February 2020, February 20th, 2020, that we have a backstop to make sure that we can extend and modify this order if necessary. So that's why that sentence was added.
I just thought 9 was all-inclusive.
9 merely just allows for modification, but not the length of jurisdiction, which is a different matter. Any other comment on that? Okay. Any other comment at all on the motion? Ms. Byrd?
Oh, I'm sorry, it's not on the motion. I just wanted to say that it is helpful when we have declarations in advance from witnesses because it does make things go faster. So, thank you.
Yes, thank you very much. And thank you, Ms. Manwaring, for putting that together as well. Okay, that's the motion. We have a second. Senator, how do you vote? Dr. Lerner, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Ms. Byrd votes?
Yes.
I vote yes. Motion passes 5-0. Thank you very much.
Thank you.
And we are done sooner than expected, but I noticed that the other parties for the other case did not leave the room, so that's good. So let's take a 15-minute break at this time, and we will reconvene at 10 o'clock. We are off the record. No. We're back on the record. I'm going to call the remaining case on our agenda for today, which is SCAQMD versus Mission Foods, case number 5400-4, for an order for abatement, which I believe is stipulated. Who is representing the executive officer today?
Karen Manwaring on behalf of the executive officer.
Thank you. And who is representing Mission Foods today?
James R.
I don't, is your microphone on?
James R. Arnold. Thank you.
And would you mind, Mr. Arnold, I'm sure it's pretty straightforward, but if you can spell your name into the record.
A-R-N-O-L-D.
Just, your mic got turned back off, so just leave it. If you just leave it so that it should be lit, that will mean it's on.
You spell my name, James, A-M-E-S-R, Arnold, A-R-N-O-L-D.
Thank you. And are you with a law firm, or what is your position?
I practice as the Arnold Law Practice. I have several attorneys who work with me.
Thank you very much, Mr. Arnold. Okay, I'm going to ask anyone who wishes to testify today to please rise to be sworn in. Do that first. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Before we begin, Mr. Balagopalan has, I believe, visited one of the two facilities, and so I'm going to turn it over to him to make sure we are not biased today.
Yes, I've been to the Rancho facility. I'm not sure of the date, either late 2015 or 2016, with some of the engineers who are present here. I believe on that, and I've seen the operation, I've seen how they make tortillas, but I'm able to.
It will not affect your
I
ability
will
to
not
sit
affect
today.
my visit would not affect my opinion, or I'm not biased to the operation.
Okay, thank you. And I assume there's no objection to
No
Mr.
objection.
Balagopalan sitting in today.
No objection.
Okay, thank you. Let's mark some exhibits that we've received. First of all, we've received 3 declarations. I believe they're all from Mission Foods. So we'll mark them as the declaration of Kevin Miller will be Exhibit A as an apple. Declaration of Paul DeLeo will be Exhibit B as in boy. And declaration of Len Ayers will be Exhibit C as in candy, because I'm hungry. And then we have a proposed stipulated findings, decision, and order for a stipulated order for abatement, and we will mark that as Exhibit 1. And we received looks like a PowerPoint presentation, looks like it's an AQMD presentation, so we will mark that as Exhibit number 2. And then I will open it to Ms. Manwaring for your opening statement, please.
Thank you, Madam Chair. And again, good morning, members of the board. A couple preliminary thoughts. I remember Ms. Byrd cautioning us not to proceed on an empty stomach, so if you really are that hungry and want some candy.
I did have breakfast.
There's plenty of Girl Scout cookies around the building I've seen. All right. Also, my opening statement is a bit longer than your custom, and despite living in California for more than 2 decades now, I do have a tendency to speak fast because I'm from the state of New York. If I'm speaking too fast or you want me to repeat something, please just let me know. I'll be happy to slow down.
It's so funny, that's my story. 2 decades here from New York, still speak that way.
Walk fast, talk fast, can't help it. All right. Thank you. With that, I'm ready to proceed. The parties are here before you today requesting that this board issue an abatement order as stipulated to and presented to you as the proposed findings, decision, and order before you as Exhibit 1. Also before you as Exhibit 2 is a 3-page excerpt from a staff report that was presented to the district's governing board at its June 1st, 2018 meeting. This is just an excerpt from the presentation that was given, I believe, by Dr. Laki Tassopoulos, and I request now, Madam Chair, that the board take judicial notice of the document as material that was presented in a public meeting to our governing board before I say a few words about this.
Okay, before I do that, I just want to ask Mr. Arnold if you have any objection to the board taking judicial notice of this presentation.
No objection.
Okay, then the board does take judicial notice, and we will admit it as evidence. Thank you.
In October of 2016, the district's governing board directed staff to reduce its permit application backlog by at least 50% in 2 years. The district's accumulated permit backlog was a problem that was recognized and acknowledged by the governing board, and the district committed its resources, including time and money. Nearly $4.5 million was spent in less than a 2-year period to reduce the backlog of permit applications. District staff was able to exceed the direction of the governing board, and instead of 50% by the end of 2018, by the second quarter of 2018, the district staff had been able to reduce the backlog of pending permit applications by 51%. You may be wondering at this point, why is district council talking about the district's successes in reducing its permit backlog when we're here about some commercial food ovens? Well, the 11 open applications for food ovens at issue in this matter, located at Missions Foods, Panorama City Facility, and Rancho Cucamonga Facility, are statistics in this issue. Part of the problem that's already been identified by the governing board with solutions that are being successfully implemented. And here we are to chip away a little bit further at that backlog. Exhibit 1 is a proposed findings decision in order that the parties have negotiated and stipulated to. It's complex, and I hope you'll agree that it is comprehensive. Basically, in order to meet BACT, so the district can issue permits to the facility will first modify its ovens with low NOx burners to address NOx, and then it will vent the ovens to VOC controls. The proposed order provides conditions addressing applications, fees for expedited review, source testing, and all the conditions that you are generally accustomed to included in your orders. You'll hear from the facility about the number of burners that will be replaced and their business needs for staggering the oven modifications, as well as time for designing and implementing the VOC controls that's necessary. There's also a unique component to this order. The order, as proposed, requires Mission Foods to acquire and hold ERCs, emission reduction credits. To be clear, ERCs are not required by District Regulation 13 at this point in the process. But including offsets serves 2 valuable purposes in the proposed order before you. First, an incentive for prompt compliance, and second, it truncates the compliance timeline. Mission may not sell or otherwise dispose of the emission reduction credits, which are a valuable offset, until compliance with this order is fully achieved. Around January, the facility began acquiring 50 pounds of ERCs for VOCs and 20 pounds of ERCs for NOx across the 2 facilities. The district estimates that when controls are installed and this order is complied with, Mission will only need to retain approximately 5 pounds of NOx ERCs for one of the facilities. That is an incentive for Mission Food to achieve compliance as soon as possible, when they otherwise could use this valuable asset. Second, the timeline for achieving compliance is truncated by this requirement. Regulation 13, which is the district's new source review rule, has a provision that provides for non-major sources like these facilities would otherwise have 90 days from the time the district notifies the facility that ERCs would be required. By requiring Mission to obtain the ERCs ahead of time, we've eliminated 3 months from the compliance timeline there. That single condition in the proposed order in Exhibit 1 may look a little strange, to just have one condition that says retain the ERCs obtained through these applications, but I'd like to point out that there were conditions precedent in our earlier versions of the negotiated proposed order. They've already been complied with. There are other conditions in this order that also are underway and have already been complied with. As you'll hear the district permitting engineer testify, the district already started to receive applications last Friday, including for both NOx controls and VOCs. So although the issue provides for 15 days from issuance of this order, for the NOx modifications to the ovens, those are already in hand. The VOC controls, this order provides for up to 90 days to provide those applications. Again, those applications came into the district last Friday. So I'm happy to report that Mission has already started to comply with these terms. Similarly, I'm also happy to report that we sent district inspectors out to the facilities, and there are no additional compliance concerns that resulted from the comprehensive inspections that were conducted at both facilities this month. In terms of full disclosure, I will share that an NC is going to issue to both facilities. One had a pressure gauge that needed to be repaired, and the other facility had an AC unit, a chiller that it needed to register. But no enforcement action in the form of notice of violation will be issued, and no additional compliance concerns arose following those compliance inspections earlier this month. Because the petition that was filed and the proposed order before you are stipulated to, you do not need to make a finding of a violation in order to issue an abatement order today. The party's burden is to demonstrate there is good cause, good reason to issue the requested order. This order is a path to compliance going forward, and I'd like the board to focus on the party's burden. Is there good cause to issue the order as proposed to achieve compliance going forward? But of course, we will discuss with you how we got here. After all, as you've seen in the petition, these permit applications have been pending with the district since 2013. I'd next like to discuss briefly the rules implicated by this order and the case we intend to present today. So, beginning with NOx emissions from the ovens at issue. District Rule 1147 was replaced by District Rule 1153. Replaced is the wrong word there. When these applications were received in 2013, they were subject to District Rule 1147. Staff had already undertaken a rule writing exercise that culminated in the adoption of District Rule 1153.1 in November of 2014. When the district passed that rule, the food ovens were no longer subject to 1147 and instead became subject to 1153.1. Pursuant to that rule, applications to demonstrate compliance with the NOx emissions were required in October of 2018. That's right, just last year. And compliance with the NOx emissions established in District Rule 1153.1 is not due until July of 2019. The district's regulation of food ovens has been evolving. But there's another interesting overlay here in terms of processing these permit applications. District Rule 219. Mission uses yeast as a flavoring, not as a leavening agent. If Mission were to discontinue use of yeast in their recipes, permits would not even be necessary for these ovens based on their size. But because yeast is used as a flavoring, VOCs are an issue, permits are required, and the other rules also apply. 1153.1, as I've just discussed, and also the district's Regulation 13, new source review. Reg 13 essentially says the district cannot issue permits to construct unless requirements in 3 areas are met: backed, offsets, and modeling. Modeling is not relevant for the issue before us today, and I've already touched on the offsets briefly when I discussed ERCs as part of the proposed order. Now backed. The district regularly updates its backed guidelines. BACT stands for Best Available Control Technology. It wasn't until February of 2018, just last year, that the district added a specific category for food ovens and required a catalytic oxidizer control VOCs from food ovens. So far, I've asked you to focus on good cause going forward to issue the requested order, and I've shared part of the story of the aging applications for these food ovens. That story involves an evolving approach for regulation of food ovens, both in terms of NOx and VOCs. What other factors are relevant to explain the more than 5-year process for the pending permit applications for Mission's food ovens? Well, District Rule 202. District Rule 202 provides that applications for existing equipment, such as Mission Foods ovens were when applications were submitted in 2013, District Rule 202 serves as a temporary permit to operate when applications are received. In other words, by operation of law, the open oven applications meant Mission was in compliance with the district's permitting regime the whole time. If this board issues an order today, the district will cancel the old applications and process the new applications as a priority that properly include NOx and VOC controls. Other factors that lowered the priority of the 2013 oven applications as the district worked through its permit application backlog reduction include the fact that these facilities are not located near sensitive receptors. There are no school districts within 1,000, there are no schools within 1,000 feet, and we're not talking about toxic air contaminants. At issue are NOx and VOCs. In other words, the open applications for these food ovens that are admittedly aging simply did not rise to the top of the priority list sooner. And when they did get the attention of the district that they deserved, the district's evolving food oven regulations, combined with Mission's different approaches to show compliance or otherwise achieve compliance with BACT and with District Rule 1153.1, further delayed the ultimate solution, which is presented to you in the form of the proposed order. Some examples: when the parties disagreed about the nature of VOC emissions from the ovens, the district allowed Mission a chance to source test the ovens. When the source test showed that the district was correct in its understanding of VOCs from the ovens, Mission contemplated changing its recipes in limiting or reducing the use of yeast, which would eliminate the need for permits altogether. And so now here we are. The parties have presented, again, as Exhibit 1, a proposed finding, decision, and order that we hope you'll issue today. In addition to the declarations that have been marked as Exhibit A, B, and C for Mission and their witness testimony, the district intends to present the permitting engineer who was assigned these applications in 2015 and 2016. It's Ms. Tracy Nguyen, who's sitting here next to me to my right. If the board would also like testimony in order to make a good cause finding that the application of BACT for food ovens, if you find that information necessary, I can track down a witness to talk about that. And if the board wants direct testimony from a compliance inspector to talk about the absence of other compliance concerns, compliance is on call and available today. But the district's intent is to limit its affirmative testimony to the permitting engineer who's working on these applications. Again, I'd like to remind everyone here today that the question before you is there good cause to issue the order as proposed going forward? Does this present an expeditious path to compliance? I believe that we've presented you with a comprehensive order that includes incentives for expeditious compliance, and the evidence in the testimony we're about to present will support a finding of good cause to issue the order as proposed. Thank you.
Thank you, Ms. Manwaring. I just want to commend you on a very comprehensive opening that really helped put everything into perspective. Thank you so much. And on that last note, I just want to remind the board that on the reference chart, which we now have, we're looking at an order for abatement stipulated Rule 806B of the district with, as Ms. Manwaring stated, we're looking at good cause to issue or good reason. Mr. Arnold, your opening statement, please.
Yes, thank you. Mission Foods has been working on this for some time, and as they came to understand what was needed, they stepped up to do it. As you know, we're talking about a stipulated order for abatement. It's the result of negotiations, and Ms. Manwaring is correct that the original applications were filed in 2013. They're simply to permit these 11 flour tortilla ovens. The company moved to accommodate and respond to the NOx issue, plan to replace the burners. You have testimony, or will hear testimony today, that the burners are on site. They're ready to begin the replacement. 2018, the company participated in attended the BACT hearings, one of them, and also had meetings with the district. The difficulty the company's had all along, of course, is that yeast was a flavoring component, not a leavening component. Therefore, the perception was, the understanding was, there simply wasn't any reaction going on. But the company did do a source test, and they do understand why it is that permits are needed. The applications for all 11 ovens were filed both for NOx and for the VOCs last Friday. We had hoped that they would be complete very soon, and we think they will be, and we will move on from there. But in the meantime, we went into the marketplace and bought emission reduction credits of an amount sufficient to offset the emissions that we believe are occurring. The witnesses that we have here today to testify and whose declarations you have before you, and I will give them in the order that I will present them, are Paul DeLeo, who is the Regional Director of Operations. Mr. DeLeo has operated the Rancho plant on an interim basis at times as the manager. He's operated other plants for the company, and he is the person within the company to whom the operators of those two plants today report to. He spends a great deal of time away from his home, out of state, in order to see to it that things are done. He will explain what the size of these plants are, what they do, the numbers of employees, the lines they have, and is available to answer other questions. Our second witness is Len Ayers. He is here with us from headquarters of the company in Texas. He's the Director of Engineering. He basically has spent his career building plants for food companies, both bottling companies such as drinks, sodas, and also food. He's an engineer with an unusual coupling of a Master's of Business Administration. He can explain how what does it take to replace burners, to add these enormous oxidizer units to each plant? What is involved with that, and the time and the condition, the situation? Our third witness is Kevin Miller. He's the Director of Environmental Services for a national environmental compliance firm. He is registered in several states. He's worked with many plants, both with this company and other companies throughout the U.S., and here also with plants in the South Coast Air Quality Management District. He has an understanding and information, participation actually in the history of permitting, ranging from earlier days all the way up until the present. And you'll be able to hear from him also. Essentially what we're seeking here is a review of the evidence in these declarations and the records. The witnesses are here available for testimony, and we seek a finding from the board that there's cause to order that the order for a stipulated order, if you would, be enacted today. So we're here to do that. I have on my left Mr. DeLeo, I have Mr. Ayers, and Mr. Miller is also here, so we can have whoever you want, whenever you want, on any of the topics that you're interested in. Thank you.
Thank you. At this time, unless there's any objection from Ms. Manwaring in the district, why don't we admit all three of those declarations, which are have been marked as exhibit, did I mark them?
Yes.
Okay, yes. Marked as exhibits A, B, and C in evidence. And that way you can proceed as you wish in terms of presenting whatever evidence you do or just opening for questions. Ms. Manwaring, any objection?
No objections. In
Okay.
fact, we appreciate that the declarations were prepared in advance.
We do too. Thank you very much. Exhibits A, B, and C are therefore in evidence. But at this time, I'm going to turn first to Ms. Manwaring to present your first witness.
Great, thank you. Ms. Nguyen, are you ready? Turn your microphone on. All right. Good morning, Ms. Nguyen. Did you take the oath today?
Yes, I did.
Could you please state and spell your name for the record?
Tracy Nguyen, TracyNguyen.
Thank you. What is your position with the district and how long have you been here?
I'm an air quality engineer, and I've been with the district for 14 years.
And are you familiar with the contents of today's petition?
Yes,
And did you participate in crafting the conditions in the proposed order?
yes, I did.
Did respondent file a permit application for 8 ovens for the Rancho plant on or about October 18th, 2013?
Yes,
Were those applications for existing equipment operating without a permit?
yes,
Did the submittals include applications for corresponding control equipment?
no,
Did respondent file permit applications for 3 ovens at the Panorama plant on or about October 23rd, 2013?
yes,
Were those applications for existing equipment operating without a permit?
correct.
And did the submittals include applications for control equipment?
No,
When were the applications assigned to you?
I received the application from Ventral in June 2015, and application from Panorama facility in September 2016.
Did the district inform Mission Foods sometime around August of 2017 that it intended to deny the aging applications for the ovens?
Yes,
And following receipt of that information, did Mission ask the district to reconsider and to work with it to evaluate various compliance alternatives?
yes,
For example, did Mission Foods propose source testing the ovens in an attempt to demonstrate that yeast-containing recipes resulted in less than 1 pound per day of VOCs?
correct.
Right. And did they propose source testing sometime around February of 2018 when we were there together touring the facility?
Correct.
And approximately what date was that source tested concluded?
The date.
The date.
Let me look at the.
Was the source testing conducted on or around June of 2018?
The sort test date is June 2018, and we received the result on sort test result on July 25th, 2018.
But Mission Foods was not successful in persuading the district regarding their position on VOC emissions through that source testing, were they?
Yes,
Ms. Nguyen, I'm going to ask the question again. I want to make sure you heard me correctly. Was Mission Foods successful in persuading the district regarding their position on VOC emissions through that source testing?
well, based on the result of the sort test, they do have a lot of VOC emission.
So would you agree that the source testing supported the district's position more than it supported Mission's position?
Yes,
Thank you. Are you aware of Mission Foods' participation in the district scientific review committee that met concerning, in part, draft back guidelines for food ovens at non-major sources like Mission Foods?
yes,
Right. Did Mission Foods request and did the district perform a backed economic analysis for the food ovens?
yes, they did.
Did that analysis show that it is economically feasible to control VOCs for these food ovens?
Correct.
Do the oven applications at issue involve any toxic emissions?
No, other than just combustion emission, it just have the VOC emission from baking, which is fermentation.
Is either facility, either the Panorama City plant or the Rancho Cucamonga plant, are either located near a sensitive receptor?
No, they're not.
Under District Rule 202, does an application serve as a temporary permit for operation of existing equipment?
Yes,
Okay. Would factors such as this, equipment operating pursuant to District Rule 202, emissions that are non-toxic, facilities that are not near sensitive receptors, are all these the types of factors that lowered the district's prioritization as it worked through its permit application backlog?
That is correct.
If no yeast is used in the recipes processed in these ovens, would a permit be required for these ovens?
If no yeast is used, they don't need to have a permit to operate for this equipment.
Did Mission Foods discuss at one point discontinuing yeast-containing recipes as a potential compliance path?
Yes,
If they were to discontinue use of yeast and not produce VOCs in their process, since a permit would not be required, what district rule would instead apply?
it would be exempt under Rule 219.
All right. And would they have to register under Rule 222?
Correct. If they have less than what the rule is say, if they have less than 1 pound per day of VOC emission, they have to register their oven under Rule 222.
When the district adopted Rule 1153.1 on or around November 7th, 2014, the ovens that we're talking about now become subject to the new rule instead of the old rule, instead of Rule 1147?
That is correct.
Does District Rule 1153.1 require, did it require respondent to submit permit applications in October of 2018?
Yes.
Right. When did respondent submit permit applications in order to comply with the NOx emission limits established by that rule?
We received the application last Friday, February 15.
All right. And are you still reviewing those applications for completeness?
Yes.
Is it accurate to say that District Rule 1153.1 does not require a demonstration of compliance with regards to NOx and CO until July of 2019?
Correct.
Now I'm going to ask you some questions about BACT as it relates to this order. Had the district's BACT guidelines established VOC BACT for non-major sources for food ovens like these at the time of the initial applications back in 2013?
No.
Is it accurate to say that a food oven category was added to the BACT guidelines for VOCs sometime in February of 2018?
Correct.
And are you aware that the district's BACT team continued efforts and ongoing discussions to update food oven VOC category even further?
Yes.
Do respondents' current operations using yeast-containing recipes in the ovens meet District Rule 1303 requirements necessary for the district to issue permits?
Yes.
Do they currently meet the requirements to issue permits?
According to information received on a new application they submitted last Friday, they do.
Okay, so after the modifications that are subject to the applications that were just received, they would meet the NOx emission limits
Correct.
and satisfy BACT?
Yes.
And after the VOC controls are installed that are subject to the permit applications that were just received, then the ovens, you would expect them to meet BACT for VOC?
Correct.
Okay. I want to make sure you heard all my questions correctly, because I know where we're going with this, but as they currently exist, is the district able to issue permits to construct for the ovens?
No.
But after the modifications are completed and compliance with this order as proposed is achieved, they will meet BACT, is that correct?
Correct.
Okay. Did the respondent submit to the district applications for ERCs sometime around January 18th of this year?
That's correct.
And based on your knowledge, were those applications for approximately 38 pounds of VOCs at the Rancho plant?
Yes.
Approximately 12 pounds of VOC at the Panorama plant?
Correct.
Approximately 5 pounds of NOx at the Panorama plant?
Yes.
And the ERCs that have already been obtained also include approximately 15 pounds of NOx at the Rancho plant.
Correct.
What, in your estimate, is the number of ERCs that Mission Foods will be required to retain before the district can issue permits?
For the new application, for a rental facility, to my estimation, they would require to have about 10 pounds per day for NOx, for ERC. And with the VOC control equipment installed, they probably don't need to have any ERC for VOC.
All right. Thank you, Ms. Nguyen. You may have heard me say in my opening statement 5 pounds. I'm going to defer to the permitting engineer. Her answer is accurate. And her response is testimony that you can accept, unlike my opening statement. All right. So if the hearing board issues an order like the one proposed before it today, is your next step to deny the old oven applications?
Correct.
And is the district committed to processing the new applications when they're complete as a priority?
Yes.
And did the facility pay fees to expedite review?
Yes, they did.
All right. And in fact, haven't you already started reviewing the applications that came in last Friday for Mission Ovens?
Yes, I did. I started work on that on the last weekend.
All right, thank you. No further questions at this time for Ms. Nguyen.
Thank you. Mr. Arnold, do you have any questions for Ms. Nguyen?
No.
Board members, Ms. Byrd.
Ms. Nguyen, I can ask the respondent this, but I just thought you might have some idea. In Ms. Manwaring's opening, she mentioned that there was a incentive to meet these dates because of the cost of the ERCs. And do you know currently approximately what they cost? The purchase of these VOCs would cost?
No,
I
I
mean, the
don't.
purchase of the ERCs would cost.
No, I don't, because I'm not the one that processed the ERC application.
Okay, thank you.
Mr. Palagopalan.
Yes, Ms. Nguyen, several questions here. When they submitted the applications in 2013, let me back up a little bit. I'm taking the Rancho facility first, and then we'll go to the Panorama one, but since I'm more familiar with the Rancho one. When I'm referring to I think it's to both because they both have ovens and the quantity is different. But the ovens, when they submitted the application in 2013, the ovens are all less than 2 million BTU, or are they more than 2 million BTU?
Yes, they are less than 2 million BTU per hour.
Right. So when 219 was changed, if the emission of VOC are less than a pound, then they would have been exempt.
Correct.
But I think in one of the declarations by Mr. Miller, he indicated that they submitted those applications in 2013 because they realized that it was not exempt because they had some VOC emission. So that's why they submitted those applications. Is that correct?
Yes. Yes.
So they had submitted an application for operating without a permit. So they got a temporary permit when they submitted. But was there information in the application there was VOC emission from the east?
Yes. When I received the application, there's a sort test report that the company conducted the test in other facility, in LA facility, and it showed that they have VOC emission.
And you say that your testimony was lots of emission. I mean, okay, I'm sorry, I'm back up. What was the reported based on that source test emission, the VOC, individually, I'm not talking about collectively from each of the ovens?
For the sort test in July 2018.
No, not 2018, when they submitted the application with test data.
The very first one, when I received the application, I estimate the emission based on the throughput of 58,000 pounds a day. And my calculation based on the formula with lowest yield, they have about 8.4 pounds per day of emission.
Per oven?
Per oven, correct.
Per oven, okay. And then subsequently, there was testing done recently, I think it's in 2018.
In June 2018.
2018. And you say there were lots of emission. What exactly do you mean? Can you quantify those numbers?
Based on my calculation, if it's based on the same throughput of 58,000 pounds per day as
Process.
As the original proposed throughput for one of the application, the estimated emission was about 11 pounds per day.
per oven.
per oven, yes.
Okay.
But the facility decide to take the facility cap, so that would lower, basically they want to propose a VOC emission for the facility for BACT analysis. So they propose the VOC, they would take the VOC emission limit and they would take that as a facility cap. So that would lower the emission per oven. Based on my calculation, if they propose about roughly about 7 million pound per day, pound per month, of throughput, and the emission per oven is estimated to be about 6 pound, 6.2 pound to be exact.
Per oven.
Correct.
Okay. And that cap is for offset purposes, or what were they taking the cap for?
For both, they need to, originally they want to take that for BACT cost effectiveness analysis.
Right.
And then that also being used for offset determine.
Okay. Now, then the district, the scientific backed group and working with, I think, the facility, came up with the BACT guidelines in 2018, right? For food ovens?
For food oven, yes.
And what's the criteria for them to put controls on based on the 2018 BACT guidelines for food ovens for minor source? What is the emissions? What should be the trigger for food oven VOC emissions for BACT?
The BACT approved in 2018 say that if they have more than 30 pounds of VOC emission per day, they need to put in the control equipment. If they have more than a pound and less than 30 pounds, they will have to do the cost effectiveness analysis. That's the understanding that we have.
Right. So in 2013, and I think we heard testimony, you mentioned that there was, when they submitted the application for the ovens, there was no food oven category. It was under a dryer oven other, and the only BACT limit at that time was for NOx at 30 ppm. There was no VOC BACT limit at that time.
Yes, it's not on the BACT guideline, but it's achievable in practice.
Right. But there was no published BACT.
Correct.
Correct. Okay. And then, but cost effectiveness is still a procedure that could have been required by you to process the application.
Correct.
And so then the determination made, and that's why I'm getting I'm all for the facility putting the control and reducing the VOC emission, which you said will be zero. That's great. But a little confused only because the BACT guideline as established and adopted by the governing board, the trigger is 30 pounds per day per oven before they need to put controls on. So are they putting the controls so that they can have flexibility in production so that, they can process more yeast and more throughput? Or what's the trigger? Because the determination made, the cost effectiveness made and published in the BACT guideline is the trigger is 30 pounds. And you're saying your calculation is less than that, right?
Let me clarify this. BACT, the new approved BACT guidelines say that if it's have more than 30 pounds per day of VOC emission, they need to have to vent the equipment to the control. That's a must because we already done the study and analysis, and it's proved that it's cost effective if they have more than 30 pounds per day. So there's no question on that. If they have more than 30 pounds, they have to put in a control. Then they're not allowed to do a cost-effective analysis anymore. If they have more than a pound per day, they subject to BACT. And if it happens to be less than 30 pounds, the applicant have option to do the cost-effective analysis to prove that it's not cost-effective to put in the control equipment. If they've done the cost-effective analysis and it's proved that it's cost-effective, and then they will have to put in a control equipment.
But when the district did the cost-effective analysis and established BACT based on the 30 pounds, and so that and that is backed for minor source currently, right?
May I interrupt with a question? Are we referring to the cost-effective analysis for establishing the back guideline or specific for feasibility of controlling at these facilities?
No, and I know I'm trying to see what the proper, maybe I'm mistaken here, but once they had to do cost-effective analysis that they worked out with it looks like it went through the review process, the backed, it was established at 30 pounds per day for minor source. That's when it'll trigger adding VOC. So it appears that the cost effectiveness was done and the determination was made and the backed guidelines was adopted at the trigger being 30 pounds. Now, it appears now you're asking that, you've asked them to do an additional cost analysis to see if it's cost effective to add controls at a lower emission rate. And you said it's about 11 pounds a day from the ovens. How many pounds was that?
A maximum is, if it's based
Maximum.
on a 58,000 pound per day of throughput,
It'll be 11 pounds per day?
correct.
So then they did the cost effectiveness based on 11 pounds per day and found it to be cost effective as to put controls on?
To be correct, the cost-effectiveness analysis that the facility conduct for Rancho is actually was done based on average of 6.2 pound per day of emission from each oven, and it's determined to be cost-effective.
So it was determined to be cost effective at 6.2.
Correct.
So then that will now, as you process this application, will then be essentially revise the current backed base potentially?
I'm not sure that that's relevant to the
Okay.
good cost finding
Okay,
today.
yeah.
And-
So now I'm trying to understand why a requirement that is contrary, I mean, not contrary, is established in BACT was 30 pounds was the trigger and, but you're saying at 6.2 pounds per day, VOC emission per oven, it was determined to be cost effective
Correct.
to put,
From the beginning, they proposed a throughput of 58,000 pounds per day per oven, and then after, they went back and, looked back in their record of production and demand, they proposed a facility-wise VOC emission limit, and that convert to equivalent to 6.2 pounds per day per oven at each facility.
and that is cost effective for.
Correct, for both facilities.
For both facilities, okay. Then, let me go to the NOx issue then. Did they test their oven to see what their current ppm limits are for NOx and CO for 1153?
There's no formal test has been conducted for NOx.
For NOx, so we have no idea what their NOx values are currently.
I believe the company talked to the manufacturer and they believe that they cannot comply with 30 ppm.
30 ppm, which is the back limit. So now they have submitted applications to put in new burners to replace the existing burners to meet the 30 ppm NOx and meet 1153.1.
Correct.
So that's part of the rule requirement, regulatory compliance requirement to do that.
Yes.
So now where's the requirement for offsets coming? Is the VOC, is the NOx emissions going to be after they apply they're putting replacing the burners to comply with the rule, and under 1303, it's exempt for if you're doing for regulatory compliance from offset. So I'm just wondering where that, I forget how many.
Just, as you ask your questions, just keep in mind that this is a stipulated order, and so the parties have agreed to.
No, I
And
agree.
we do not
I'm
need
just
to make
trying
a finding
to.
of violation,
Yeah,
so.
I'm not trying to find the violation, so I'm just trying to understand the sequence and what where the requirement for the 15 pounds of, is it 5 pounds, I think?
Mr. Balakapalan, In my opening, I referred to 5 pounds. Ms. Nguyen then clarified that it's 10 pounds are what we expect they will need to retain in order for the district to issue permits. But you also may recall in my opening that I said ERCs are not required yet at this point in the process.
So I think Ms. Nguyen testified they need 10 pounds of NOx ERC.
Right, in order for the district to issue permits, they will have to obtain NOx ERCs, correct?
Right, my understanding of the testimony so far and the opening statement was that they are not required to purchase as many ERCs as they did at this time, but they're doing that as part of the stipulated order, and Ms. Nguyen's is that 10 will be required.
Before to issue the permit.
Correct. Right now, Rancho Cucamonga facility, they have PTE above 22 pounds per day already. So meaning permitting any additional equipment to the facility that would require the ERC to offset the NOx emission increase.
Right. Okay. Even though they are installing it for regulatory compliance, and there's an exemption in 1303 for if you're doing that for offsets.
The exemption applies to the control equipment, not the underlying process unit.
Yes.
And for those members of the board that are not as familiar with Reg 13 as Mr. Balakabalan is, offsets
but-
are considered on a facility-wide basis. BACT is applied at the specific equipment level. We want to be clear in the language that we use in explaining that.
Yeah, I want to make it clear again that 10 pounds per day of NOx ERC required for Rancho facility is actually for the ovens. It's not for the afterburner.
Right. Okay. It's not for the okay.
Yes.
So let me go back to so they've submitted application. You have applications, 8 applications for the Rancho facility and 3 for the existing temporary permit to operate. Now, they've applied for the replacement they've applied to replace the NOx burners, so they've submitted modification application.
Correct.
So that'll be linked to the old application. What about, and so they've also applied for VOC control, to put in the control for VOC.
Correct.
So when you issue the permit for the modification, and would you also be doing at the same time the requirement for them? I mean, I'm assuming you're going to issue the permits to reflect the new burners for what they, that'll meet the NOx limits, which is what they submitted the application for, right?
Correct.
And then are you also going to be then putting permit conditions that will require them to vent it to a VOC control?
Yes,
same
because
time.
they already submit application for the control equipment as well.
In fact, that's included in the proposed order I'd like to draw your attention to.
Oh, right, just that I saw the timelines were different, so I was wondering when they, because there were different timeframes when they have to submit each application, so the requirement.
The understanding as the order was being negotiated is that there would be greater time needed to design the VOC controls. Therefore, we gave them a longer lead time. So we were quite pleased when we learned that the applications for the VOC controls also came in on Friday.
So
The oven applications required, they include being vented to the VOC controls as a first step. And
Right.
then,
No, I understand. So I just wanted to be clear that there won't be another requirement to submit again. It'll be all contained in that permit that you're going to reissue basically for the facilities.
We're going to issue the permit all at once for changing replacing the burner and venting that to the control equipment at the same time.
Yeah, that's okay. That's what I wanted to know. Okay, thank you.
Mr. Nguyen, do you foresee, you stated that you already have begun reviewing the applications. Do you foresee at this point any issues with the applications?
No, besides just the additional information that I requested from the company that they need to provide me, additional document about the equipment they're going to put in. Other than that, I don't see any potential problem for approving the permit.
And so do you see that the timing would be within a reasonably soon?
Yes, I would expect that if I
less than
have,
5.5 years?
Notwithstanding the past.
I would expect that we'll be able to complete the application. If I receive the information I need for the application package, I would be able to, I have no problem to complete the evaluation for that and approve a permit within 2 weeks.
Oh, okay, that's even sooner than I would have thought. Thank you for that. I had no other questions. Anyone, Ms. Byrd has another question?
I just wanted to, and I'm not sure if you can clarify this or if Ms. Manwaring needs to clarify this, but in the proposed order on page 4, there's a sentence under number 15 that I just need to reconcile that there's nothing about, that will change. And it's, the last sentence of number 15 says the district's SPAC team continues to engage in ongoing discussions to update the food oven VOC category further. We're not talking about ongoing discussions to update anything for this facility.
Correct, correct. That is
Just in
just generally to
general.
support the concept that our regulation of food ovens continue to evolve.
Okay.
We anticipate no further rule changes and no updates to the back guidelines
And the
before these permits are issued.
Okay, I just wanted to make sure that I was clear on that. Thank
That
you.
was explaining the past. That does not reflect any potential impediment going forward.
Okay, thank you.
Anyone else have questions? Senator?
In the order, the timeline specified is in terms of days after certain action had taken place. You set days. Early on, when you talk about a finish date is July 1st, 2019, if certain things had occurred prior to that date.
I think this is a legal question about District Rule 1153.1.
That's from I'm on it. Yeah.
Yep. Applications were required by October of last year. The facility did not meet that deadline. Compliance is not required to be demonstrated until July of this year. In other words, we often do schedules in our proposed rules. You submit applications at one period, and then you actually have to complete those modifications for the next period.
Was there a protocol test required prior thereto? Or at that time, in order to meet that timeline, would you have needed to have a protocol for testing?
My answer to the legal aspect, that is, no, there are no testing protocols at issue here. Ms. Nguyen, do you understand the question?
If it's just a general question for to prove compliant with Rule 1153.1 requirement, normally they require to submit application by October 1st, 2018. And by that time, if application come in, we will be able to process that. And normally, the permit issue would require a sort test to verify compliant. And normally, they have to demonstrate that compliant by the deadline stated on the rule.
Right, which is July 1st, 2019.
Correct.
And then my question then therefore is applicable. At what point in time prior thereto would you have had a protocol test?
This one, after we issue the permit to construct for this equipment, and as soon as they replace the burner, they can just go ahead and run the sort test. I believe the order of abatement required them to submit a protocol for review first before they conduct the sort test.
Senator, in other words, there's the potential here for compliance in advance of the rule requirement. The potential.
Well, yeah, it just seems logical to me that if you set a date for compliance, and in order to determine that the compliance has been accomplished at that date, you would have needed to have a protocol source test prior thereto. And my question is, did you have such a source test in place?
Ms. Nguyen, do you understand the Senator's question?
No.
Would you please ask the question again for us?
How would you determine that they were in compliance as of July 1st, 2019, if there were no protocol or source test in place?
For the
Pursuant to
permit, after we issue the permit for this equipment, permit always have a condition that require them to submit this protocol for review, and they have to run the sort test within Normally, the standard condition require 180 days after they replace the burner.
Well, then it's not possible for them to have been in compliance by July 1st, 2019, if they filed a petition based on October 1st, 2018.
Yes, I think so.
They couldn't.
Yes,
They
because
couldn't
we
make the
will issue the
timeline.
permit for them as soon as
All
we
right.
can. And, you know, they have to, after we replace the burner, they have 180 days to run the soil test.
So those timelines should be acquired based on the order, is that what you're saying? Will be met based on the dates that you stipulated to in the order.
Yes.
Yeah, to be clear, the proposed order is tighter than the rule requirement here.
I can see it's tight. I was just thinking about the expectation. All right, thank you.
Mr. Balagopalan?
Just as a clarification to the Senator's question, I think they're proposing to stagger retrofitting the ovens over a period of time. So some of the ovens may not meet the 2019 deadline, and that's what the order addressing. Am I correct?
You're exactly correct with that, and that's why I said the potential for advanced compliance. We anticipate some ovens will likely have been tested and shown to be in compliance with the rule requirement prior to the July deadline, but due to the staggering for the facility's business needs, some may come in after.
And that's what the order is addressing, that staggered replacements of the oven.
Yeah. Thank you, and
Thank
thank you, that clarifies.
Any other questions for Ms. Nguyen? Okay, thank you. Seeing none, Ms. Manwaring, do you have no other witnesses, or did you plan to?
No other affirmative testimony. Again, we have the compliance inspectors on call. There are people in the building that could talk about BACT if necessary. But I do believe that the testimony that's been presented and will be presented by missions witnesses will be sufficient to establish good cause.
Makes sense to the chair. Mr. Arnold, then I'm going to turn it over to you, and I'm going to remind you that we have admitted all of the declarations in as evidence, and to ask you how you wish to proceed. Do you wish to affirmatively introduce each of your witnesses and allow for questions, or would you like to entertain questions? How would you like to proceed?
We would like to proceed in the most efficient manner possible. Therefore, what I will do is ask the witness a few questions and then ask for the declaration to be given evidentiary weight. I mean, it's been introduced as evidence. It's been admitted. And I think that will help focus us and keep us moving along.
Thank you. Mr. Arnold, why don't you proceed then?
Okay, our first witness is Mr. Paul DeLeo. And as I mentioned before, he has a role in operations.
And
Paul?
just to orient the board, we have marked Mr. DeLeo's declaration as Exhibit B as in boy.
Yes, Exhibit B. Mr. DeLeo, how do you go about supervising the operations at the company's plants in Panorama City and in Rancho Cucamonga?
I do random visits on a weekly basis.
And explain for us whether you have ever operated or been the manager of either of these plants on a daily basis.
What was the question again? I'm sorry.
You operated one of the plants for a period of time when there was not a manager designated, is that correct?
That's correct.
And when was that?
That was this past year in 2018, from the month of June to the month of September.
Now, you've said in your declaration that the company employs 240 people at the Panorama plant and 744 people at the Rancho plant. Explain for us how running the lines at the plant, how much time that takes, how many people are working on a particular line. First, let's set the basis. Number one, first question, how many lines in total do you have at the Rancho plant?
There's 23 production lines.
And how many lines in total do you have at the Panorama plant?
There's a total of 6.
So let's talk about the Rancho plant. You've got 23 lines, you have 240 people, excuse me, you have 744 people working at the Rancho plant. How many people work on the lines? Or how many people are affected, say, if a line were to be shut down?
If one particular line was to go down, it could be anywhere from 7 to 10 people.
Now, you regularly shut the lines down for cleaning anyway, don't you?
Yes, we do.
How often do you have to do that?
Once a week.
And how long is the line shut down while you're doing that?
It can range from 48 hours to 24 hours per week.
Now, you don't have a steady state level of production, do you?
No, it doesn't. It's customer driven, based off of customer orders.
And are there any variations during the year in those orders and the rate of production that you're doing?
Yes, everything is seasonal and promotional driven.
And so what seasons?
Basically, during the summer months, during Cinco de Mayo, and summer into 4th of July, going into Labor Day is typically our peak season.
And
or higher demand.
and explain for the board what are promotions?
Anything that the retailer might be promoting, including our food service, such as some of our restaurant customers. They do periodic promotional activities.
Let's talk for a minute about the workforce you have at the plants. You said in your declaration that about 45% of the workforce at Panorama have been with the company for 5 or more years. Is that correct?
Yes, that's correct.
And that the workforce at the Rancho plant has been with the company for 10 or more years.
That's correct.
Why is there a difference in the time that these people have been with you at these two plants?
The Rancho facility's been in existence longer.
Now, as far as the educational background, what level of education do you have among your employees? I mean, what does it take to be an employee, to be hireable, say, by your company at one of these plants?
Well, there's different skill levels that's required. We have very simple labor where boxes are stacked or tortillas are put into plastic bags. So it's very low skill level. Where you have a higher skill level, maybe required high school education or up to high school education, where you have an operator that's running a line, adjusting controls, and running the production line, basically.
Now, if you were to say, at the Panorama plant, that you were to shut down all 3 lines, how would you go about doing that? Would you shut them all down I mean, if you were shutting down 3 lines, assume that you're shutting them down all at once, well, what effect would that have on your employees, or the number of employees you have working?
Yeah, that would basically lay off people for that period of time.
So
It would have no work.
how many, you said in your declaration you lay off 120 employees,
Yeah, that's correct.
and you would lose 60% of your payroll?
That's correct.
And the payroll then translates into also about 60% of your production?
Yes, that's correct.
And wouldn't it be possible, this is off of your declaration, other than your declaration, wouldn't it be possible simply to ship in more product from plants in other states?
Yes, that's a good possibility, yes.
What's the shelf life of your products, though?
It ranges anywhere from 14 days all the way to 35.
And for your restaurant customers, are they sensitive to shelf life?
Yes. And their shelf life is basically up to 21 days in most customers.
Now, you said 50% of your Rancho plant, excuse me, if you shut down all 8 lines at Rancho for the 8 to 12 weeks to replace burners and install the VOC emission controls and get the operating permits, you would need to lay off about 200 employees and lose 38% of your payroll. If you were to be shut down for 8 to 12 weeks and you have 38% of your payroll or 200 employees laid off, what would you expect to happen to those employees as far as being available when you started back up again?
Yeah, we could lose some of the workforce. They would not wait.
Are there other jobs available for them
Yes, there's currently now, yes, with the
economy?
economy the way it is, yes, there's plenty of jobs.
Now, do you use yeast all the time in all the ovens that are being permitted here?
No.
Explain how you decide when to use yeast and when not to use yeast.
Well, we have particular recipes in our formulations. Not all of our formulations consume yeast.
So different types of products would have a yeast flavoring or some other kind of flavoring, depending on what
that's
the
correct.
formulation is. Is there a particular demand for yeast as a unique flavor?
Yes, there is. And we have some consumers and customers that prefer the flavoring of yeast in their products.
I have no further questions of this witness, so maybe if the prosecution, the district, would like to ask any questions of Mr. De Leon.
Yes, I'm going to turn it over to Ms. Munwaring if she has any questions.
Yes, thank you. Just a couple cleanup questions, if I may. Mr. De Leon, referring to your declaration on page 3, paragraph 9, it reads, "The lines produce flour tortillas. See the flow charts attached as Exhibits A and B." The copy of the declaration that I have did not have Exhibits A and B attached. My question to you is, are they available, or would you prefer to strike that sentence referring to exhibits that aren't here?
Well, we would prefer to strike that. That was a typographical error.
In other words, there are
Yes,
no
there are
exhibits
no A and
attached,
B.
so let's
Yeah.
just strike that for clarity.
Thank you. We are going to, since these have been admitted into evidence, I think it's important that we strike that. So, again, that's on page 3, between lines 22 and 23, paragraph number 9. The flowcharts are attached. The flowcharts attached as Exhibits A and B are stricken.
I have no other questions for this witness.
Thank you. The only question I had, Mr. DeLeo, is that the point of your testimony, I assume, is to support the fact that the proposed order does not require all the lines to be taken down at the same time. Is that correct?
That's correct.
Okay. And then, is your microphone on? I just want to make sure your microphone's still on and to you.
Yeah, that's correct.
Okay, thank you. And then I'm referring to page, do you have in front of you the proposed order? I'm referring to page 7 of that order, which talks about the burner replacements, at least 50% to be replaced at each location within 90 days, and then to complete 100% within 180 days. In your opinion, in terms of the testimony you have given regarding your workforce and the need to take down those lines for the period of time that is required for each, is that the in your mind, the most reasonable or the quickest time frame possible without overtaxing, overburdening the workforce, laying anyone off, or losing employees?
Yes, that is correct.
Okay. And that was what this, was that what, to your knowledge, was that what paragraph 7 and 8, those timeframes, those percentages, was that designed to take into account the loss, the potential loss of workforce?
Yes, that is correct.
Okay, thank you. Anyone else have any questions for Mr. DeLeon on, sorry, not DeLeon, sorry, Mr. DeLeo for his testimony? Ms. Byrd, did you?
Go ahead.
Now, I just wanted to confirm, I think it says this in your declaration, but yeast is only used when customers are requiring that for the recipe, particular recipe.
We use it in our recipes as well.
You use it, but you don't use it in all recipes.
Not in all recipes.
Okay, so it's really when it's dictated by the requirements of your customer that it's
Yes.
used. So these ovens, while they are in use, potentially also have there will be times that they're running and there are no emissions because there's no yeast being used that would meet this requirement.
Yes, that's correct.
Okay, thank you.
Mr. Balagopalan?
Mr. DeLeo, those ovens at the Rancho facility, are they dedicated strictly for flour tortillas? Or do you,
Yes, the 8 lines are dedicated for flour tortillas.
what about do you do corn tortillas at the facility?
Yes, we do, but no yeast is used.
No yeast is used on that. You use the same line for those two?
No, they're different
different
types of lines, different design.
So what kind of flavoring does yeast produce? It's not in the product. What does it impart as far as, I'm just curious on the taste or what?
It's just a unique flavor.
So the different types of yeast used depending on the recipe?
Yes, there's only one. It's instant dry yeast.
Oh, okay. Thank you.
I'm sorry.
Ms. Byrd?
I just wanted to follow up because I'm just a little bit confused. I want to make sure I got this right. When I ask you, are these ovens, these particular ovens, I understand you have more ovens, that's correct? And these particular ovens do run the yeast flavored, and they're the only ones that run the yeast flavor, is that correct?
That's correct.
But they don't always run yeast flavored?
That is
That's
correct.
Okay, I just wanted to be sure. Thank you.
Anyone else have, Senator, did you have questions?
Madam Chair, I may have asked this question before, but for my clarification, I'll ask it again. On page 7, line order number 7, you can shut down in each plant 50% to be completed within 90 days. Let's see, 50% is modified pursuant to within 90 days. And 180 days, the whole place, you should have it all done, is that correct?
Yes, on the declaration is correct.
And does that mean that your staff will be laid off for at least 180 days, half of them?
We'll be rotating them within,
Well, half of them, of the total number, will not be working for 180 days, is that correct?
they'll be off. We'll be rotating them in, finding them work, but it would be just a 2-week period where there'd be a loss of labor. But we would be rotating them in because we'd be extending the lines on the other production lines in order for them to continue the process and work and to complete orders.
So it's wrong to assume that 50% of your staff will be deactivated for 180 days then?
May I ask a couple questions? Just to clarify, the paragraph number 8 means that within 180 days, all of these lines will be, the ovens will be modified. Is that correct? Is that your understanding?
The burners,
All the burners will be replaced. How long does it take for each line to be down, requiring certain labor to be redistributed for each burner replacement?
We're planning on 2 weeks, but we're giving us some time for about a week to get the lines back up and running and do some testing. So we're planning just 1 week as far as lines being shut down.
So it's not that all these lines will be shut down for 180 days. It's that within that period, each line will be shut down for 1 to 2 weeks at a time.
That's correct.
Okay. Does that make sense? I don't know if there's okay. Any other questions then? No? Any other questions from anyone else? Okay. Thank you very much, Mr. DeLeo. I want to move along this matter as quickly as we can. Because the chair will be lost at 1 o'clock for a training, so I want to make sure we are all done and we have that taken care of. What's that? You'll go on without me? Will find me. Mr. Arnold, you do not need to repeat all the testimony if you do not wish to in the declaration. We'll accept it, but please proceed. Who would you like to introduce next?
Our next witness is Mr. Len Ayers, who is the Vice President of Engineering at Mission Foods, and his declaration is available to you. He will explain what is going on with the engineering here, and will be available to discuss what kind of parameters they have to work within to replace burners, how many burners there are in each oven, and you already know how many ovens because you know how many lines there are. That's already been in the record here. And then he also will be able to discuss what is going on with this oxidizer VOC controls. What is that all about? What does it mean? Are these small units or bigger units or whatever? So he's available for that. And of course, to explain anything that is in his declaration, which we believe has most of the information that's necessary.
Okay, if you can introduce Mr. Ayers at this time, state his name, spell it, although it is spelled in his declaration, and then just state that he has taken the oath.
Yes. Mr. Ayers, would you spell your name for the record, please?
Len, L-E-N, last name is Ayers. A-Y-R-E-S.
And is this your declaration?
Yes, it is.
It's been evidence? Good. Okay. And you are the Vice President of Engineering?
Yes, I am.
And you're familiar with the facts as set forth in your declaration, which explain the engineering concerns and the process for scheduling both the burner replacements and the VOC controls being installed, correct?
Yes, sir.
I have no further questions.
And you took the oath today, Mr. Ayers?
Yes, I did. Thank you.
And, well, you know what, I'll just open up for questions. I think it's self-explanatory. Ms. Manwaring, any questions for Mr. Ayers?
Yes, please, just a couple questions, Mr. Ayers. Thank you for your declaration. We have not yet heard the amount of money invested in the purchase and acquisition of ERCs. Do you know what, and the chair had asked that question earlier, do you know what the cost for the ERCs, for the VOCs or NOx were?
Yes, I do.
What is that?
It's about $1.3 million and some change.
Okay, so that was,
including fees, it's a little more of the fees for the purchasing and stuff.
okay, so over $1 million was spent in securing those ERCs. Thank you. Now, referring to your declaration, page 5, I'm looking at paragraph 14 that starts on line 5. You refer to local permits. Could you briefly describe to us what local permits are necessary for this project, and what is the status of applying for local permits, if you know?
Well, currently the status of local permits, we've not applied for them until we have drawings that would be used as part of the application process. The permits that are required would include not only utility impacts with electricity and gas utility services that have to be permitted, but one of the bigger ones would be as we put equipment in, especially some of the equipment that's directed, that's planned to be placed inside the building, we'll have to have an architectural review to make sure we don't have any egress issues with people or life safety issues that have to be considered as part of that. So there'll be multiple parties as part of that input for the permit process.
And are you the individual that is working with the city of Panorama or the city of Rancho Cucamonga in order to secure those permits when you're in a position to seek them?
We have hired Oxidizers Incorporated as a prime contractor who would take that responsibility. They have that experience and will help us navigate those technical challenges of getting the permits issued and getting them approved.
Okay, so Mission has already hired someone who is more familiar with local permitting issues. Okay, no other questions for Mr. Ayers.
Thank you. Mr. Ayers, earlier, Ms. Nguyen of the district had testified with regard to her process of permitting, of reviewing the applications that have been submitted for permits, and she had mentioned some additional information that had been requested of the facility. Are you familiar with that request?
I think the request was relative to some P&ID details for the oxidizers that we're in the process of getting that piece of information for her.
Okay, that was my question. Do you know if that information is forthcoming?
It is.
Okay, thank you. Anyone else have any questions? Ms. Byrd?
And just as a means of just as a means of explaining why it's an incentive for the ERCs, can you tell us, you purchased 1.3 million approximately with fees, and when you don't need them, what do you expect to receive when you sell them back on the
I think,
market?
we haven't crossed that road yet, but my expectation is we'll ask ourselves when we get there, do we anticipate any future business that might change before we decide to release those? But unless we have a business compelling reason, we would consider that as an economic decision to be made to sell them back possibly, if the market is good for that at that moment.
So if it was explained that this would be an incentive, how would this be an incentive for you? It was explained in Ms. Manwaring's opening, and I'm not saying that you follow that, but what would be the incentive then? I know they cost a lot, but what would be your
They do cost a
incentive?
lot. From our perspective, we believe that they have value and relative to a marketability at the end of this. If we decide and choose that we want to let go of some of them and sell them, that would be at our option. As far as an incentive, I think it's for us to show goodwill and intention that we're going down a path of complying and doing the right things. Obviously, I guess we could have had a discussion and taken more of those credits and try to push that as an issue, but I think it's the right thing for us to be doing at this point and taking those on, and then it gives us the freedom later on, once we're in compliance, to make decisions that are better for the business, whether we want to turn them back in or use them for further business adventures that we'll take on.
Okay, thank you.
Mr. Balagopalan?
Mr. Ayers, has Oxidizer Inc. Been out to the Rancho and the Panorama facility, and have they done the evaluation on the oxidizer location, or what's involved in that?
Yes, they have. Our original plan was to place oxidizers on the ground in Panorama and design structural supports to carry the infrastructure for an oxidizer in Rancho. They've been out there since, and we've met with the plant to discuss alternatives, and we think we have a good solution where we can help ourselves by not building a structural infrastructure to carry that device on the roof, but carry it at the ground level possibly. So that's what we're anticipating.
Outside the facility?
Actually, it'd be inside the facility. We have a battery room where we have vacated the battery room, and it's almost the ideal place to place it. And it keeps the ductwork to the right dimensions, because the bigger challenge in the installation is having ductwork that's too long. It gets bigger. The longer it gets much bigger in size and dimensions.
I see, okay. So then the intention is to, all the lines from at each of the facilities will go to each of those oxidizers?
Correct.
Okay, thank you.
Any other questions for Mr. Ayers and on his testimony or declaration? Seeing none, you have one further witness, is that correct, Mr. Arnold?
Yes, ma'am.
Okay, well, I'd like to take just a quick 10-minute break and then come back, take that final witness in the same manner, and then we can proceed to closing and deliberation. So let's go off the record till just a little bit past 11:40. Okay? We're off the record. We are back on the record, and I believe, Mr. Arnold, you had one final witness to introduce.
Yes, ma'am. Thank you. Yes. I'm calling on Mr. Miller, whose declaration is Exhibit A. It's been admitted. Mr. Miller, would you spell your name, please, for the record?
It's Kevin Miller, in Kevin Miller.
And did you take the oath?
Yes, I did.
What do you do as Director of Environmental Services at U.S. Compliance Corp?
I oversee our regulatory division, which includes everything from environmental permitting to on-site visits, filing reports, developing compliance plans for general manufacturing across North America.
How long have you been working with Mission Foods on these two plants, Panorama and Rancho Cucamonga?
I started working with Mission Foods in 2008, and I started working with these two locations in 2011.
So you've been involved with the permit process that began in 2013, correct?
That's correct.
And you're involved with the permit process today, correct?
That is correct.
And it was you that filed, or actually, it was you that prepared so the company could file the applications for these permits on Friday, the 15th.
That is correct.
And you're, on behalf of the company, you're negotiating and discussing with Ms. Nguyen questions and items that are needed for the permits to be deemed, for the applications to be deemed complete.
Yes, that is correct.
And were you involved with the efforts to understand and work with the draft-backed guidelines on behalf of the company, that is?
Yes, I've been supporting Mission Foods and kind of understanding of all the regulatory changes regarding BAC guidelines and some of the other rules that we've been discussing today.
And who prepared the economic analyses that the company has submitted?
With information supported through Mission Foods and some of the oxidizer companies, I prepared the calculations.
And did you prepare the calculations in support of the purchase of the emission credits?
Yes.
I have no further questions of this witness.
Thank you. Ms. Manwaring, any questions?
The district has no questions for Mr. Miller.
Board members, anyone have any questions for Mr. Miller? Mr. Balagopalan.
Mr. Miller, in your declaration, it said that August 30th, 2018, the district informed you that the VOC control was not convinced that it was cost-effective. And then did you subsequently, after that, prepare any other cost-effective, change the cost-effective evaluation to show it's cost-effective?
We completed an original submittal that, based on the information at that time regarding the number of oxidizers in the process, that submittal indicated that it was actually not cost-effective, but through further discussions, we resubmitted some documentation in support of installing the oxidizer.
So at what level of VOC emission is it cost-effective now?
I don't have the exact details, but I'm in agreement with Ms. Nguyen on kind of the quantities she was mentioning, around anywhere from that 6 to 11 pounds per day.
Okay, thank you.
Senator, you had questions?
It says here on page 2 line 5, that you're generally familiar with the compliance history of the units at Mission Food Plant. Right? And you've been there since 2008?
I've been working with Mission Foods as a corporation since 2008. These two locations since 2011.
Okay, my next question is that, to your knowledge, how long were they in operation before you start working with them?
I don't have the exact timeline. The units were in operation. Our first task was to review the process to determine whether or not permitting or reporting was being done correctly. And one of the items we discovered through discussions is that the yeast was in the product, and that is what triggered the submittal of those applications.
Were they operating with or without a permit before you came to work for them?
I don't know that.
When were you first committed then? I mean, when were the first to apply for a permit?
Yeah, so when we applied for the permits, they were using yeast.
When was that?
It was discovered in the 2012 year.
That's when you applied for, that's when they applied for a permit.
Correct.
But you have no knowledge that at that time were they permitted?
They were not permitted. They were operating underneath the 219 exemption.
Say it again, I'm sorry.
Sorry, they were operating underneath the 219 exemption as units less than 2 million BTU.
Exemption, okay.
Yeah.
Okay, thank you.
Any other questions for Mr. Miller? I see no more. Thank you. Mr. Arnold, does that complete all of your witnesses?
Give me a moment.
We're off the record for a moment.
Yes, it does. Oh, excuse me.
Good. We're back on the record.
Yes, it does. That completes our presentation.
Thank you very much. And thank you for the presentation on the declarations. That always helps the board to have that in advance and makes the hearing go quicker. At this time, I'm going to ask if there's any member of the public who wishes to be heard on this matter. And I don't see any. So, Ms. Manwaring, I'm going to turn it to you for your closing.
Thank you, members of the board. This was a fairly complicated order that we've presented to you today, and it took a long time to get here. But we have a path forward, a path to compliance, that the facility will achieve compliance with both NOx and VOC emission limits, and that will meet back so that the district can issue permits to these facilities. ERCs have been acquired in advance, and following Mr. Ayers' testimony, you may have the impression that I oversold the idea that this is an incentive for expeditious compliance, but I still stand by the fact that holding on to $1 million asset that you're not using is not the business decision that this facility is going to make. I can't put words in the witness's mouth, and I do understand there's a market for ERCs and prices fluctuate. That is their business decision to make. But truncating the timeline is set in statute. By having the ERCs in advance, we have cut the compliance time by at least 3 months that the facility otherwise would have had to go out into the market and get ERCs that it would have needed. Permit applications have been submitted in advance of the requirements proposed in this order, but I'm not suggesting that we change the order because until they're deemed complete, it's not in compliance with the terms proposed. The district, as you heard the permitting engineer testify, is committed to prioritizing, processing these applications, and in fact, she estimates that she'll only need 2 weeks to complete the process after she has all the information in front of her that she needs. With that, we ask that this board find good cause to issue the order proposed as requested. Thank you.
Thank you. Mr. Arnold, would you like to make a closing statement?
Nothing more than that we agree with the district because we've negotiated this stipulated order. We believe that that both parties have acted in good faith and that there is sufficient authority, in our opinion, for the board to approve the order. Thank you.
Thank you. Board members, anyone wish to begin discussion on this matter? Ms. Bird, you'd like to begin?
Okay. I do believe that we can find good cause to issue this order. This is a stipulated order, so we did not have to find a violation. And the district concluded basically that there were 4 things that needed to happen. One, that they would buy the ERCs, they'd modify the oven burners, they'd install the VLC controls, and then reapply for permits. And this order basically takes them through those steps. This is one of those cases where, and every now and then we get one of these, where things change between the time that a facility actually applies for a permit, the rules change, and then all of a sudden we're here. So this was one of those situations. I believe that it was not at the fault of the facility itself, even though we don't have to find fault, but the district is in a process of catching up with processing permits, and this was not a high priority permit based on the requirements at the time that it was submitted, but it became more of an issue later on when the requirements for BACT for ovens went into place. So the facility has already purchased the equipment to replace. They've already purchased equipment. They're ready to go. They've submitted their permit applications. They've bought their ERCs. And now the district has them on a timeline to get this done as expeditiously as possible. And while I would agree with Ms. Manwaring that, and sometimes I'm just waiting for the witness to give us that information. Most of the time I'm waiting for the witness to give me that information. But knowing the cost of ERCs and the value that's associated with them, I can see that it might cause them to act more quickly if they are sitting on a $1.3 million worth of ERCs. Let's see. The facility mentioned that the yeast is not always used in the process. It's really customer based, but the changes that will be made to the burners and to the controls will still keep those emissions down. This is an expeditious process. Some of these burners will be in compliance prior to the deadline that was set for July. However, they won't all be in compliance, but this process will keep them on track to assure that they reach compliance as quickly as possible. And for those reasons, I do believe that we can find good cause.
I agree with that, and I also just wanted to add that I think that this particular stipulated order was well negotiated between the parties. I think it strikes a very good balance between getting some of those ovens in compliance, possibly, quite probably, given how the applications were already put in well in advance of when they would have been required, and will likely be granted within 2 or more, a little more weeks. Between getting some of these in compliance before the July deadline, some of them after, but still striking that balance so that labor is not too affected, those workers are not too affected, and people don't either get laid off or have to seek employment elsewhere. And so for all those reasons, I also can find good cause. And Mr. Balagopalan, you had some additional?
No, I agree. It's a well-negotiated order, and we'll get the facility on the path to compliance, both with the NOx limit for rule and BACT, and also the fact that they are going to put a VOC control gives them, if they need to, additional flexibility on the amount of material throughput and the yeast content they can process, because now, as we heard testimony from Ms. Wynn, that there essentially will be zero, they said, VOC emission after the control, which will have at least a minimum 95% reduction. I do want to point out, and I know it's not been approved yet, and I see both a supervisor and manager here, that that there is an exemption under 1304C4 that they may want to look at just to make sure that the correct amount of NOx offsets applied, and that I think we can find good cause.
Anyone else have any thoughts or wish to add to the discussion? Senator?
I agree it's a good stipulated agreement. No hardship is imposed on the respondent. That the staggering of the employees from one line to another minimizes, under this agreement, minimizes the time that they will not be working. And that's pretty good. And from the standpoint of supporting the employees, all of them, for a period of time where they're not off work, which I think is a good idea. Good stipulated agreement.
Thank you.
I'll say
Anyone
that.
else? Anything else? Anyone wish to make a motion on this? Mr. Balago, Pollen, why don't you go ahead?
Yeah, okay. In the matter of South Coast versus Mission Foods, case number 5400-4, I think we can find good cause and agree to the stipulated finding and order, and with and I move that we adopt it with no changes to the order, as presented.
Other than just to delete the words proposed?
Oh, yes, I delete the word proposed to.
And for the record, you're referring to that which is marked Exhibit 1?
Correct. Exhibit number 1, yes.
Thank you. And I will second that motion. Is there any discussion on the motion? Senator, how do you vote?
Aye.
Dr. Lerner, how do you vote?
Yes.
Ms. Byrd, how do you vote?
Yes.
I vote yes. Mr. Balagopalan?
Yes.
Motion passes 5-0, and thank you all for a very good presentation.
In order, without changes, and a compliment from the senator. Thank you very much. We do appreciate this board's attention to this issue this morning. Thank you.
Well done, thank you.
I do that?
We
Go off the
also,
record before he takes it back.
Quickly.
we also express our thanks for listening to us, and our thanks to the district for seeking a collaborative solution to this joint problem. So thank you very much.
Thank you. Board members,
We have
Senator, did you have?
jurisdiction till what time? Jurisdiction.
Jurisdiction is aptly stated. I was gonna ask the question of whether I think it's December. It's an either or, depending upon which comes sooner, but it's December 31st, 2020, which, given what we've heard today, that the applications are already in, that they will be forthcoming pretty soon. It seems to me that that timeline is very consistent with what we heard
December
today.
2020, thank you.
Okay, any other questions, anything else? Okay, board members, before we adjourn, I just wanted to say, since this is the first time we've received, and thank the clerk's office for making this happen, this laminated quick reference chart. I would just suggest that this is not something we would take home. I would suggest it's something we keep here, since it has to do with our deliberation and motion making. And is there any other business, board members? If not, we are adjourned for the day. Thanks.